Hello dear friends, welcome back. This is Indus Lex and today we are going to discuss section 69 of Bharati Nyaya Sanhita. Dear friends, section 69 of Bharati Nyaya Sanhita deals with the offense which particularly caused against women on in the pretext of false promise of marriage or a false promise of employment or a false promise of promotion. The core of this section is deceitful means, that the deceitful means by way of three methods, such as suppose a person promise a lady by suppressing its identity that he is not going to marry her in a future, or he is already married, or he will give the employment in lieu of the sexual intercourse, or we can say for the promotion. Although it seems that there is some immorality on the part of women, but if a lady or a woman says that look, that person promise me to do marriage or to give promotion or to give me an employment, in any of these conditions, if that person on makes a sexual intercourse with the woman, and later on if the woman lodge an FIR alleging that I have given the consent because I believe that, or that person told me, promised me that he will going to marry me in a future, and therefore I come into the relationship with him. This is ambit of section 69. If anybody make a relationship on the behalf of making promise that he will marry with that lady, but later on if he is unable to marry that lady and that lady lodges FIR, then the FIR is lodged under section 69 of B.N.S. What is the repercussion of it? Repercussion is that suppose that there is a long relationship between two couple, and due to some unforeseen events marriage not took place, then in in the form of revenge or in form of frustration, that lady may move an application that we are in relationship, we are in consensual relationship, but that consensual relationship is only because that person has promised me that he is going to marry today, or now he is denying. So this is section 69. What is the defense? Dear friends, when FIR is lodged, you have to see the punishment prescribed in this section. Particularly for section 69, 10 years of imprisonment is there in the statute. So the section is punishable by the punishment of 10 years. Therefore, now the investigating officer who will investigate firstly record the statement of 161 CRPC, now 180 B.N.S, and then took that lady to the magistrate for recording her statement under section 183 B.N.S. Then for the medical examination, doctor will record her statement. After completing all these formalities, including the spot inspection, the most important part is that the recording of the statement of the accused. But how the statement of accused will be recorded? It will be recorded when police take that person into the custody. And if you don't want to go into the custody and nobody want to go into the custody, he has two remedy at that initial stage just after the lodging of the first information report. First one is criminal writ jurisdiction, where you challenge the FIR by mentioning that after perusal of the FIR no offence is made out as per the section 69 of B.N.S., or you go for anticipatory bail. But you have to understand the difference between the criminal writ and anticipatory bail. Section 69 and anticipatory bail is something very equivalent in the terms of, we can say, how much success rate is there, whether your criminal writ petition is going to be succeed or your anticipatory bail is going to be success. In general term, or in, I can say in generally what I suggest is that whenever an FIR is lodged, and if you believe that you are innocent, firstly challenge that FIR, try to get arrest, try to get stay on arrest, try to get quashing of your case. And again in this section, when section 69 is lodged, I would suggest that you must try your luck before the Honorable High Court by way of filing the criminal writ challenging the first information report. As usual, success rate of criminal writ is always, when we discuss on its merits, when we discuss on its power of the court to grant relief, anticipatory bail is at larger footing, because the major difference is that you will get arrest stay or stay on arrest in the first information report challenging the criminal writ only when you will demonstrate the court that this case is the result of malicious prosecution. If the court is satisfied that your case is going to be quashed in a future, or if the charge sheet will come, that charge sheet will be quashed, that entire proceeding is a malicious, is abuse of the process of law, then your criminal writ petition is become fruitful for you. However, on other hand, when we talk about anticipatory bail, its comparison with the bail. Why an accused person put behind the bar? Obviously, when there is a heinous matter, then there is a chance that if the accused is outside and not behind the bar, he may tamper the evidence, he may influence or threaten the witnesses, he may abscond also. Therefore, he must be behind the bar. But Article 21 says jail is exception. So at this footing, when you have a constitutional right under Article 21, right to the freedom, right to life. Right to life is a foundation of our constitution. So you have to tell the court that your case is not required any custodial interrogation. To get success in the anticipatory bail, you have to focus and you have to demonstrate why your custodial interrogation is not required. Dear friends, suppose that there is a case in which a person fire a bullet and FIR is lodged, that person is fleeing away. In this case, if he approach the honorable court, then honorable court will say that look, there is allegation that you fired from a weapon, and if you will not get arrested, how the weapon will be recovered? on this very reasoning, there might your anticipatory will be rejected. Suppose that there is a particular case of robbery or dacoity or something else, or of the organized crime. If you plead before the court that, look, my name come in the statement of co-accused. So here is a very divergent view of several courts. Some courts believes that in the law of evidence, confessional statement of the accused is not an evidence. Therefore, if a person name disclosed in the confessional statements, then that will not be the ground to reject the anticipatory bail. But some courts, there is opinion that if the name is disclosed in the confessional statements, then there must be interrogation of that person so that he may tell that what more person is involved in that crime. So the very purpose of the bail or anticipatory bail is that that person promising that he will participate in the trial, he will appear before the court whenever asked. And why anticipatory bail is important? Anticipatory bail is important because you will get the opportunity to surrender yourself and just release on bail without going into the custody, by promising, by fulfilling the bond, that you will appear before the court whenever asked. So you have to hammer for the anticipatory bail, try to find out why your custody is not required. Now come on section 69. Dear friends, section 69 is a private offense. It is a private offense, although it is a state case, but the victim and the accused, only the two persons are there, and victim has already given the statement under section 180 B.N.S before the police, 183 B.N.S before the magistrate, and further give the statement before the doctor. So there are already three statements of the victim during the investigation, and further he will be examined before the court on oath. So there is no additional evidence will come. There is no requirement that somebody is something we have to find out by way of investigation or by way of interrogation. Whatever the facts are, that already told by the victim to the police or by the informant to the police. And generally in a practical aspect, what we see, that suppose that police not lodged the FIR under the section 69, what the person has remedy? He has remedy to move an application under section 156(3) CRPC to the competent magistrate that, look, this person make false promise of marriage and made relationship with me. Now he is denying the marriage, or he is already a married person. Then most of the time, at the time of adjudicating your application for the registration of FIR, court finds that this is a case in which investigation by police is not required. Let the evidences directly record in the court, and at that stage, in the maximum cases, 156(3) CRPC application convert into the complaint case, and then magistrate record the statement under section 200, and if any witnesses are there, then recorded their statement under section 202 CRPC, and then pass an order to summon the accused or drop the complaint. Meaning thereby, if the police is lodged the FIR under section 69 B.N.S. Here, no role in the entire investigation of the accused, because whatever the allegation are there, that are sufficient, and victim has already demonstrated all the facts to the police, and there are no such material which need to be undercover. So in these cases, success rate of anticipatory bail is 99.99%. So if there is a false allegation against you under section 69 BNS, don't lost hope. You definitely going to get the anticipatory bail from the court. But as I always tell, try your luck before the criminal court, because once you satisfy the honorable court at the stage of challenging the first information report, and suppose court finds the merit in your argument, in your case, then he will grant an extraordinary relief to you, that is stay on arrest, and further call counter affidavit by the state and by the informant. And if your petition is going to be succeeded, your first information report will finally be quashed. What anticipatory bail does? Anticipatory bail protect your personal liberty, but criminal writ protect the false criminal proceeding against you. And suppose that during the time when the affidavits are going to be exchanged after months, in meantime police filed a charge sheet against you, then you again has opportunity to challenge that charge sheet along with entire criminal proceedings before the court in the competent jurisdiction. Once you get stay over your case, you don't no need to face the trial. But if you get anticipatory bail, you have to face trial. But we have to understand that when an FIR is lodged, person become panic, and it is obvious because police are raiding your house, police are calling your relatives, trying to arrest you, trying to catch you, and the fear of arrest, fear to go behind the bar is one of the deadliest fear a human can face, because jail is the institution which make by human, although lots of thing, lots of institution, lots of goods are invented by the human being, but suppose that human makes temple, we have make temple also, we have make garden, we have make plane, train, etc. But remember, human being make jail also, that is a prison also. And prison is something worst place to go, because it made for giving you punishment, although there are several theories that prison must be like this and that. But as we know, in the reality, even we don't have good hospitals for all the person, for all the citizens, so we can't tell that go in prison there is a luxury life like a hotel. And in a prison means only for that you appear before the trial court. So dear friend, if any of your relative, your friends are prosecuted under section 69, tell him, dear, no need to worry, be safe from the police, don't surrender yourself. If you have very few money in your pocket, then directly approach to the session court for anticipatory bail. And if you fail to get the anticipatory bail from the session court, attempt to get the anticipatory bail from the High Court. 99.99% cases in the section 69 you will get the anticipatory bail from the High Court. But if you can afford, always try to get quash your FIR, because in most of the cases what happened that there are a couple who are in the relationship, and if that relationship not turn into the marriage due to frustration, another party lost the FIR under section 69. What will be the ground for bail if you got arrested? So be remember, this is a good case for anticipatory bail, even though it is not for quashing in many cases. So if you can get anticipatory bail in these cases, so there is no doubt that you will not get the bail. So if your relative got arrested, don't be panic. He will get the bail on first date in the High Court. If you are on the if you are on the you are not got arrested, try to get the anticipatory bail order from the court. Thank you.